I don't know what your point is. That's not the issue right now. The issue is that you're not, but you're not on the lease. There is also some other huge problems that I'll adjourn it out a week. She needs to be here.
Okay.
And how do I want to say this? I'm not sure the import of all of this change of venue document. I mean, I can rule on that now. That's going to be denied because it's not a change of venue. The other thing is that other individuals, and I may indeed strike the entire documents that have been filed because you cannot change the caption to the case, which apparently somebody decided to do.
Change the caption to the case. What do you mean?
Well, I'm not here to give you legal advice. If you want to raise those issues, you're going to have to do it in the proper way. The documents that are filed here are not done in the proper way. So at this point, I don't think it's advisable to even hear it. You are also, well, maybe a resident in the premises, you are not the leaseholder, and I don't have the leaseholder here. So I'm giving a break by I'm not letting them take a default today, but all of these documents and everything have to be in order. I'm not requiring the plaintiffs to answer. And I'll hear everything, but until everything's in order, I'm not going to waste my time.
District Court, County of Washington, State of Michigan is now in session. All those having business draw near. Judge J. Cedric Simpson presiding.
And good morning, folks. Court does call the case Arbor House versus Robert Gallet.
Good morning, Your Honor. Sidney Katz on behalf of plaintiff.
Gallet, not checked in. If you'd like to take a default, raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth to help you God.
I do, Your Honor.
Go ahead, sir.
Your Honor, this is a termination of tenancy, unauthorized occupants. At this time, requesting a default judgment. There is a second mailing with the court as well, requesting a writ date of May the 11th.
All right. Court in reviewing everything sees that everything's in order. Judgment to the plaintiff. That's by default for possession. No redemption amount. Writ to issue in 10 days.
Thank you, Your Honor.
Sir.
Have a good weekend.
Thank you. You do the same. Huron Vista versus Takia Roberts.
Good morning, Your Honor. Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Good morning. Takia Roberts.
Yes.
Okay, there you are. Your camera's blocked, but okay. What is plaintiff's claim in this case?
Good morning, Your Honor. We do show that currently there is past due rent in the amount of $3,335 with court costs of $220.81 for a total due owing of $3,555.81.
All right. And Ms. Roberts?
Yes.
All right. How are you intending on getting that taken care of?
Right now I am waiting to hear back from my unemployment. My unemployment was messed up. They have to fix the dates and take some things off to get it reapproved. So I'm waiting for that to come through. And then my parents are helping me.
Hold on, slow down. You're waiting on whom to get everything adjusted?
My union rep to fix my the thing that's going on with my unemployment. They put some wrong information on there and it was basically rejected.
Gotcha.
So they have to fix it and resubmit it. And then my parents said they could help me out towards the 15th, but it will have to wait till the 15th. But I am signing up for jobs and looking. I'm also signing up for school, so I'm trying to see what my schedule would be like to have a job. But
Okay.
I'm getting help.
All right. All right. So there's basically unemployment compensation issue, right?
Yes.
And then that. Okay. So this is May 1st already. Okay.
Yeah.
All right. So what I will do is, ma'am, I'm going to adjourn you to my next date, which is May 8th.
Okay.
Okay. 2026 at 12 noon. Let me ask you this. In between now and then, is there anything that you can pay?
I don't have anything on me. The most that I've been able to pay is DTE because that's the most that I've been getting. Um,
Okay.
as for help from family members.
All right.
Your Honor,
Okay, well, pay. Yes,
we do have a conflict on the 8th. Is it possible to get the following week?
the 15th.
Yes, Your Honor.
Yes,
And that
we
would
can
also
do that.
allow time if she's able to get those.
If she's going to pay, right?
Yes.
So you said your parents can help you on the 15th?
Yeah, they're looking to help me. Also, my grandparents.
Okay. All right. So what I'll do is I'll adjourn it to May 15th, 2026 at 1 p.m. That's an in-person hearing, okay? So you'll
Okay.
have to come down to the courthouse. All right. But in between then, whatever your parents or grandparents or whoever's helping you can pay, that would be great. And then we'll see where we are. Okay, Ms.
Okay.
Roberts?
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Have a good day.
Okay, you too. Yeah, this is short docket. Well, who's coming in and just leaving? Gulfside Lake 3 versus Emmett Redwine.
Good morning, Your Honor. Jillian Engen for plaintiff.
Good morning.
Yes.
Oh, there he is. I knew I couldn't. Your name was on the docket. You were going to be here. So, how much do we have owing?
Your Honor, including May rent, I have a total balance and court costs, $4,386.49.
All right, Redwine. How are you intending on getting this paid?
I'm gonna have, cause we get paid 5 times this month, right? Let's see. I'm gonna have 1,000 paid back by next week. I have it paid before this month is out. I can have it all paid.
All right, I got you, but let's work it this way. I'm going to adjourn you out to the 8th. Okay, so between now and next Friday, how much can you get in?
Minimum 1,000.
Okay, so about 1,000.
Yeah.
All right, so I'm going to indicate that you're going to pay that. Try to get that paid by the 7th. Okay.
It won't be if court the 8th.
Yeah, so you're going to. All right, I'll just make it the 8th. That's fine.
It'll be paid first thing that morning.
Okay, so I'll adjourn this then out to May 8th, 2026 at 3 p.m.
Okay.
Okay, and that's in person, so you got to be here, but get that money paid in. All right.
Yes, Sean.
All right. Take care. And then Sparrowwood Apartments versus Carmen Pope. That matter is dismissed on plaintiff's motion without prejudice. And I think that's the shortest Fink docket ever.
Can't get any shorter
That's right.
and have us still be here. So
have a great weekend.
thank you, sir. You too.
Chestnut Landing LLC versus Martis Hall.
Good morning, Your Honor. Attorney Bearta Salem on behalf of plaintiff.
All right. Good morning. And I think Miss Hall was here.
I am here. I just don't know how to turn my camera. I'm sorry.
Yeah. Okay. I'll need a camera, sir.
I don't know how to. Oh, let's start. There we go.
Got it? Okay.
Yes, sir.
Okay.
What is plaintiff's claim in this case?
Your Honor, rent to retain is $10,414.25. Court costs are $191 for a total of $10,605.25.
Okay. And Mr. Hall, how are you intending on getting this paid?
So previously, my identity was stolen and kind of messed up my bank accounts and a lot of different things, but I got all of that taken care of. I get a check in 2 weeks regarding my back pay of my paycheck that was inside of my bank account that was frozen. So I can pay either the entire thing or at least half in the next 2 weeks, but the full amount will be paid in this month.
Okay. Let's do it this way. How much can you pay by next Friday, you think?
Next Friday, since there's literally all of my accounts are frozen, probably nothing. But in 2 weeks, I get my bank account unfrozen. I get checks.
Okay. All right. So I'll just mark that in the file. What I'll do, sir, is I'll adjourn it out 1 week. You're entitled to that. So May 8th, 2026 at 3 p.m. That's an in-person hearing, so you got to be down here, unless everything's paid in full. And then we'll see where we go from there, okay?
Yes, sir. You said May 8th, 3 p.m.
3 p.m. Yes, sir.
Yes, sir. Thank you, Your Honor.
All right. Thank you.
No problem.
Your Honor, just for clarification, does plaintiff have to appear in person too?
Ask Miss Dornbush.
Okay.
There's a little bit of an arrangement on that. All right.
Okay.
Spice Tree Apartments versus Fatma Musa.
Fair to Salem on behalf of plaintiff, Your Honor.
Good morning, Your Honor.
Good morning. You'll have to uncloud your camera.
Yeah, give me 1 second here. Can you see me?
Yeah, we can see you. Okay. First of all, and I doubt plaintiff knows, I think, did we send over this to Pallett's office?
Yes, Your Honor, we got it this morning.
Okay. There was voluminous documents filed, and I'm not clear I understand all of that. Are you still in the apartment, sir?
Yes.
Your Honor, just for the record, Fatma Musa is the defendant in this case. Is she there with you?
Fatma Musa and all other occupants. So that's what we're here to talk about.
Where is she? Where is she?
Fatma Musa, my mom? She's sleeping.
Who are you? Who are you?
I'm her son, and I'm the occupant, and I have.
What's your name?
Abu Bakr Ibrahim.
Say again.
Abu Bakr Ibrahim. So
is she residing in the apartment?
Petition for she doesn't reside in the apartment, she's just a leasing tenant.
Well, that's a problem because she's the one that's on it.
Yeah, I can have her come into the next court meeting in person.
Well, the problem is that she's supposed to be here today.
Your Honor, we didn't receive this notice until the 27th.
Not my issue.
Yeah, there's no.
That's timely service, sir. So that's not the issue. The issue is that the defendant is not here.
Right.
And I don't know.
A notice to quit was put in March 5th. We didn't get. Okay.
Thank you.
Thank you.
Spice Tree Apartments versus Andrew Fuller.
Fair to Salem on behalf of plaintiff, Your Honor.
Or here.
They dropped. Okay. Counsel, I'm going to pass this to the end. They were here and then dropped off. So, maybe they're back. Hello.
Hello.
What's your name?
Andrew Fuller.
Okay, they're back. Okay. What is plaintiff's claim in the case?
Rent to retain is $5,653.02. Court costs are $169 for a total of $5,822.02.
All right. Mr. Fuller, how are you intending on getting that paid?
Your Honor, I was told that it was $4,169.50. So I was gonna pay the $4,000 today. So I'm lost about the $5,000.
Well, hold on. Is that number that you the number that you gave of the 4,000, did that include your May rent?
No, Your Honor.
Okay, that's going to be the difference.
Okay.
Okay, and that comes out about right, because if you're going to pay 4,000 a day, that's going to leave you about 1,822 left. Your monthly rent's about 17, and you got court cost on that. So It's about right.
Okay,
Got it?
I got it.
Okay. So what I'm going to do is I'm going to adjourn this out to the 8th, May 8th, 2026 at 3 p.m. That's an in-person hearing if everything's not paid. And Mr. Fuller, you're going to pay $4,000 today?
Yes, Your Honor.
All right. So get that paid over to your landlord today. And then we'll come back in a week. We'll figure out where we are and see if we can get this taken care of. How's that sound?
Thank you. It sounds great. Thank you, Your Honor.
All right. Thank you. We'll see you next week.
Thanks.
Spice Tree Apartments versus Alana Grimes.
Here to Salem on behalf of plaintiff, Your Honor. Actually, this matter was dismissed. We e-faxed the dismissal to the court yesterday.
Okay. Didn't get down here, but that's okay. Case is dismissed on plaintiff's motion without prejudice. And Spice Tree versus, is it Zanhanta? Is it Juno? Or Juno? Are they here? I'm sorry. Second defendant. Brandy Noble. Brandy Noble? Juno? No. If you'd like to take a default, raise your right hand to be sworn, counsel. You solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do.
All right, go ahead.
Thank you, Your Honor. Rent to retain is $3,982.55. Court costs are $182 for a total of $4,164.55.
All right.
Judgment to the plaintiff, that's by default. For possession, redemption amount is in the amount requested with the writ to issue in 10 days.
Thank you, Your Honor.
Thank you. Spice Tree versus Brian Meeks. And there is another
Good morning.
defendant, but there's no reason for me to do that because that doesn't happen. Good morning, Mr. Meeks. All right.
Good, sir.
What is plaintiff's claim?
Rent to retain is $3,137.20. Court costs are $182 for a total of $3,319.20.
All right. Mr. Meeks, how are we going to get this taken care of, sir?
I can get that completely caught up and paid by the 20th. By the 8th, Your Honor, I can pay I'll pay $800 or more by the 8th. And then also, Your Honor, I know this would normally be adjourned to an in-person hearing on the 8th. My older brother just passed away, and that is actually the day of his funeral. So I don't know if there's anything I can do.
That's the date of his funeral?
That is the date of his funeral. It's at 1 o'clock in Detroit.
Gotcha. All right. Over the objection of plaintiff, Mr. Meeks has been before me before. He's a straight shooter. He would be telling me that if it weren't true. He also gets himself to the point where he gets this paid. So I'm not, unless his whole personality and everything has changed, which I doubt. I'm going to adjourn this one out to the 15th, 2026 at 3 p.m. Okay. I'll adjourn it to then. Try to get the 800 in, Mr. Meeks.
Yes, sir.
All
Yes,
right.
Your Honor.
That, and my condolences to you and your family. That's always tough, right?
Yes, sir. I appreciate that. Thank you.
All right. Okay. You take care of yourself.
You as well. Thank you, sir.
Spice Tree Apartments versus Jenna Stribley.
Not sure.
Jenna Stribley, not here. Counsel, you may proceed. I should say Nathan O'Neill. Stribley, O'Neill, not here. You may proceed, counsel.
Thank you, Your Honor. Rent to retain is $3,575.89. Court costs are $182 for a total of $3,757.89.
Judgment to the plaintiff. That's by default for possession. Redemption amount in the amount requested with a writ issue in 10 days. Valley Ranch versus Cameron Hall. and Juana Mitchell.
Beatrice Salem on behalf of plaintiff.
Good morning.
Good morning. Your name?
Cameron Hall.
Okay. All right. What's plaintiff's claim?
Rent to retain is $3,311.69. Court costs are $182 for a total of $3,493.69.
All right. And Ms. Hall, how are you intending on getting that paid?
I'm currently in school, so I've reached out to financial aid to see what can be done. I'm also on summer break, so I'm turning my part-time into a full-time job, and I just applied to another job on the side.
Okay. So you're a student.
Yes.
Okay, where?
The University of Michigan.
Oh, that school. All right. No, I'm sorry. I'm a Maryland grad, so that's what I say. Anyway, so you're reaching, when you say that you're reaching out to financial aid, what do you mean by that?
They have I just filled out a budget paper thingy, and they'll see if they can extend the financial aid.
Gotcha. So, okay. I see what you're saying. Okay. Do you know when they may have an answer on that for you?
No, but I can go in today or on Monday and see.
Okay. All right. So here's what I'll do, young lady, is I'll adjourn this out to May 8th next week, 2026 at 3 p.m. Okay. And that's an in-person hearing. So see what you can get worked out. Do you think that there's anything that you can pay between now and next week?
Yeah, I do get paid this week, but well, not this week, next week, but I'm not sure how much I'll be able to pay. I'll pay as much as I can though.
Okay. All right. Spoken like a true student. All right. So all right. So get something paid in. I'll just mark that it's a question mark as to what you can do because you're operating off your paycheck and don't know how much. Okay. And do that, and then we'll see you next week at 3, and we'll figure out where we're going to go from here. Okay?
Okay, thank you so much.
Not a problem. What are you studying? What are you going to be when you grow up?
Sport management.
Sports
So I want to
management?
yeah, I want to work in sports, specifically football or basketball.
Oh, okay. So when I start my NBA career, you can help me out?
Yeah, I got you for sure.
Okay. No, that's not going to happen. I'm way too short for that. I don't have the moves, but whatever. All right, young lady, you take care.
Thank you, you too.
All right. Whitaker Oak versus Wendy Allen and David Norris.
Your Honor.
Wendy Allen. Oh, go ahead, Counsel. I'm sorry.
I apologize. We filed a dismissal with this yesterday.
That one too?
Yes.
All right. That case is dismissed on plaintiff's motion without prejudice. Whitaker Oaks versus Mark Majeski. I think he's here. And Connie Majeski. All right. Mr. Majeski, can you hear me? You'll need to unmute, sir.
All right. Am I good?
Yep, you're good. All
Okay.
right. All right. What is plaintiff's claim?
Rent to retain is $1,520.71. Court costs are $243 for a total of $1,763.71.
All right. And sir, how are you intending on getting that paid?
Well, the information I got from the office was for $1,024.73. I don't know where the extra $500 is coming from. Does that include May's rent as well?
Yes, it does.
Yes.
Okay. I made an arrangement to meet the property manager after my work hours last night. I told her I'd be in front of the office to give her the $1,024.73 at 7:15, and she never showed up. So I have the money orders for everything up until May's rent.
Okay, so you have 1,024?
1,025.
Okay. 1,025. And is the office open at particular times?
They're open now. They weren't
Okay.
open at that point in time, but I had called yesterday afternoon about 2:30 and told Danielle what was going on, that I'm a car salesman, that I had a late delivery and that I could be there by 7:15, and she agreed to meet me and then never showed up.
Okay, that's fine. I'm not gonna so much worry about that. You think you can get that 1,025 down to them today?
Absolutely. I got to go to work, so I
Okay.
got to drive right by there.
Okay, fantastic. Get that paid today. I will then adjourn this out 1 week to May 8th, 2026 at 3 p.m. That's an in-person hearing. And then we'll see where we are and see if we can get this resolved. How's that sound?
I plan on having the balance paid by then anyways, because it's rent time.
Okay. So if you pay it all off, then what's going to end up happening is you won't need to show. Just make sure everything's paid. You won't need to show, and they'll dismiss the case.
All right.
Your
Okay.
Honor, if I may, just for the record, the total amount that I provided today does have May rent, but it does not have sewer and water charges. There was some issues with getting those numbers before today's hearing. So I just would like to clarify that for the record.
Okay. So there might be some additional sewer charges and other. Okay.
Will that be included in what?
Go ahead, sir.
Will that be included in the balance, or can I pay that after I pay the balance? Because I don't want to get caught up, and I don't want to. It's very hard for me that this is happening. So,
okay, Mr. Modest, listen. Let's just work it this way. Get the 1,025 paid. Then you said you're going to pay your rent at some point, right?
Right. Before then.
So pay your rent. If for whatever reason those sewer charges aren't there yet or whatever, and there's some additional amount on there, I'm not going to let anything happen to you because you're going to have the bulk of this paid off. So don't.
Okay.
I get that it's hard. I'm not going to let anything happen. You'll be good.
Okay. Thanks, Judge.
All right. You take care.
You as well. Have a great weekend.
You just say, what kind of cars do you sell?
Fords.
I like him. I'm a Ford guy, so if you said Chevy, I was gonna kick you out of the Zoom room. Anyway.
Okay. All right. Well, let me go sell some Fords.
What'd you say?
Let me go sell some Fords.
All right, sir. You take care. Have a good. Whitaker Oaks versus Hunter McNiff. And
I do see the
McKenna. Yeah. Ashley. All right. I don't know why the syllables aren't happening. Ashley, what's your name?
Ashley McKinka.
I did say it right. See?
I think so. I didn't hear you right away.
Okay. No, it's like everybody around me was yelling at me saying I didn't say it right, but I thought I did. Anyway. Okay, they weren't, but whatever. All right. What's the claim in this case, counsel?
rent to retain is $1,698.20. Court costs are $243 for a total of $1,941.20.
All right. And ma'am, how are you guys gonna get that paid?
So I did give them money orders in 1,700 last night. I delivery drive, so I can't give it for sure when I can give the rest. But I should be able to get it to them by the 5th. The rest of, I think the 5th is like Monday, I believe. Oh, the 4th is Monday. So over the weekend I should be able to give them the rest to catch up April. I am also waiting for the deposit of my state taxes just so I can pay ahead May as well. As
Right,
well
but
as,
this number, hold on.
go ahead.
This number, council, includes May.
Correct.
That
And
one
we
does-
do
okay,
have
so-
that $1,700 payment reflected on our ledger.
Right. What did you say, council? I'm sorry.
The $1,700 payment made yesterday is reflected on our ledger.
Oh, okay. So that's already paid. That's already on there. And she still owes the 1941.
Correct.
So
Okay.
May rent by guaranteed will be paid in full by May 11th. I did tell them May 10th yesterday by accident, but I didn't realize that was a Sunday.
Okay, so here's what I'm gonna do. May 8th, I'm gonna adjourn this out to May 8th, 2026 at 3 p.m. That's an in-person hearing. What I'm
Okay.
gonna suggest you do is contact the attorney's office or contact your management, see if you guys can work out how you're gonna get all of this paid up.
Okay.
Okay, and whether it can be a consent judgment or a conditional order dismissal, just to try to get this resolved, all right?
Okay. Thank you very much.
All right, thank you. Have a great weekend.
You too. Bye-bye.
Whitaker versus David Petrowski and Vicky Pitt.
Hello.
Hello, sir. All right, Mr. Petrowski. All right, so what is plaintiff's claim?
Rent to retain is $3,172.21. Court costs are $243 for a total of $3,415.21.
All right, and sir, how were you intending on getting that paid?
I can pay $1,500 today, and then I can have the rest by the 27th.
All right, so $1,500 you can put in today?
Yeah.
Okay, so get that paid. I'll adjourn this out 1 week to May 8th, 2026 at 3 p.m. That's an in-person hearing. In the interim, contact the plaintiff's attorney's office. You'll see it on your paperwork. All right, and see if you can work out either consent judgment or conditional dismissal. Since you have in your mind how you can get this paid before the end of the month, okay?
Okay.
All right. Thank you, sir.
Thank you, sir. Have a good weekend.
You too. Say that again. What's this? Oh, okay. All right, counsel, I think that's it for you.
Yes, it is. Have a
All
good
right,
rest of the day. Thank you.
And I'm not going to say you did a better job than Dornbush. All right?
Have a good one.
We'll make that our little secret. All right, take care.
Bye.
Bye-bye. Okay, Ridgewood Apartments versus Anthony James. Ridgewood Apartments, Anthony James, indicate neither party appeared, case dismissed.
Good morning, Your Honor. Olivia Camaro appearing on behalf of Plaintiff Pierce Lake Village Association.
Good morning, Your Honor. Travis Gagnon appearing on behalf of defendants James E. Heaton Trust and Tenant.
Your Honor, can we address a housekeeping matter prior to getting into the motion, please?
What is the housekeeping matter?
So at the February 20 hearing that we were at, it was relayed to the court that defense counsel represents all defendants, and I wanted to confirm that defense counsel does in fact defend all defendants. He advised the court that he was planning on filing a motion to dismiss the Ellen Trust on the basis that she had no alleged interest, and that motion has not come through, and their captions seem to state that they only represent the trust, the Heaton Trust, and the tenant. So if that's the case, I'm going to need to default the Ellen Trust, but I just want to confirm.
We filed an appearance on behalf of the James Heaton Trust and Tenant only. It is still our position that the other trust has no ownership interest in the unit that's in question. And again, It's not that I won't file a motion. Our motion that is teed up today is to adjourn the trial, which would seemingly bump the motion hearing or motion filing deadlines as well. That will likely be a part of the motion that's filed at that time.
I don't know if that's a housekeeping matter or not. I mean, if you believe that they're not representing them and you want to file a motion for a default, I think you need to file your motion.
Understood, Your Honor.
All right, Mr. Gunyu, it is your motion, sir.
It is. Thank you, Your Honor. Hopefully it's a simple motion here. On April 10th, we had a hearing in front of this court, and we had set the date for a non-jury trial for May 5th. At that time, only counsel was required to be present at the hearing, and counsel checked their schedules, and it was clear of any conflicts for the May 5th deadline, or for the May 5th trial date. Within that following week, I was able to meet with my clients, explain to them what the next steps were, and that there was a trial that had been set. It was only at that time I was informed that there had been a long-standing travel that had been planned by my clients, who are not only just named defendants here, they are representatives of the trust that owns the unit, but also key witnesses in the trial, that they would be out of the country, and I think it was until May 18th. Given that it was a 3-week lead time or a 2-week lead time at that point, they were not able to cancel their travel. And I, that same day, reached out to chambers and counsel to try to see if we could set another trial date, whatever the soonest available trial date was, following their return to the country, May 18th. We were given June 2nd as a potential date and told that we should stipulate. I communicated with counsel via email and phone calls several times. I wrote them that day. I wrote them the following week. A couple of times in follow-up. I left 2 voicemails and I never heard back from counsel. So without hearing anything further, I filed this motion to adjourn the trial date so that I could have my key witnesses as a matter of due process here, so that we have are able to present our defense. In the response, which is the only response that I've heard back, whether email or formally or informally, they cite MCL 600. Got 5735, 2 different sections. These are for summonses,
I know.
So
I'm well aware of that. And I'll get to it when I hear their response, because I think the response is frivolous in a lot of ways.
Yeah, and I will just point out, Your Honor, my last thing. We've already extended deadlines in this case before at plaintiff's insistence. We had our hearing in March. That was scheduled. Plaintiff reached out and asked for a stipulation to move that date, which again is far beyond 10 days from the filing of the complaint. We did stipulate to that and moved it to the April 10th date to cooperate with counsel. Now we're being told that it's not a matter of discretion and that there's no power to move beyond based on this good cause. So that is all I have, Your Honor. Our request is that we move the trial date to June 2nd. Or if counsel or plaintiffs are unavailable on June 2nd, we're happy to find another date that works where everyone is present.
Response.
Your Honor, MCL 600.5735 sets the dates that the summary proceeding must occur after the issuance of the summons.
How long have you been doing summary proceedings? Because what's the date of that statute?
It's been effective since, it's at least amended since 2004.
Correct. And in 2020, particularly Supreme Court Administrative Order 2020-17 changed that, correct?
I would need to verify, Your Honor.
Yeah, you should have looked at that before you filed this response. Go ahead.
Your Honor, we largely rely on our response to the defendant's motion.
Yeah, but I've got questions regarding the response, because what you put in the response, it seems to me to be frivolous regarding an argument for a motion to adjourn the trial date. You're indicating that the court doesn't have discretion, that there's got to be a hearing, without any analysis of the original statute that provides for service and a hearing date from within the 3 to 10 day range. But that's when trials weren't held in the manner that they're held right now. And so I don't think that you necessarily, if you want to try to explain what all of this that's in here, then you might want to do so, because I consider many of the arguments that you make here absolutely frivolous and not taking into account the statutory and court rule changes that have occurred regarding summary proceedings.
Respectfully, Your Honor, again, our position is that the statute places a limitation on the adjournments and
Give me the court rule, by the way. Court rules will supersede statutes on procedural matters. That has always been the rule. So give me the court rule that does not give this court discretion to adjourn this trial.
I mean, Your Honor, under MCR 2.001, the court rule yields to the statute.
On procedural matters?
The language in 2.001 specifically states that the rules in this chapter govern procedure in all civil proceedings in all courts established by the Constitution and laws of the state of Michigan, except where the limited jurisdiction of a court makes a rule inherently applicable, or where a rule applicable to a specific court or a specific type of proceeding provides a different procedure. Our interpretation of that specific type of proceeding provides a different procedure, read in conjunction with the Summary Proceedings Act, which provides.
Be kidding me. Read the first sentence again.
The rules in this chapter govern proceedings in all civil proceedings in all courts established by the Constitution and laws of the state of Michigan.
That's it. The rules govern the procedure. So why didn't you, and also the rules do require where somebody reaches out to the opposing side that there is to be some type of either concurrent or not concurrent in a motion that's filed or a request. So why didn't your office respond to defense counsel's request? I'm not saying what the response has to be, but the very fact you didn't respond.
Yes, Your Honor. So while Mr. Ganyu, and I apologize if I misstated that, when he called me, I was in a client meeting, and then the email had already come in that he was moving to adjourn it. And so I didn't have the time to give him a call back and explicitly state that we weren't going to proceed with concurring, but my understanding or my position was a non-response is the same as not.
No, it is not. That cannot be your response. You're going to tell me when opposing counsel reaches out to you, even if you don't agree, that you have no obligation to respond? Is that what you're telling this court?
No, Your Honor, was intending on originally giving him a call back, but the motion had already came through. I was in a client meeting when he called me.
Your Honor,
You're saying there wasn't a time between his original contact with you and the filing of the motion that you had no way of reaching back out via email otherwise to him? Is that what you're representing to this court? Be careful on your answer.
No, Your Honor.
That's not what you're saying to this court, because I really hope you're not.
No, Your Honor.
You have previously adjourned dates in this case, correct?
Correct, Your Honor.
And you sought the concurrence of defense counsel to adjourn those dates, correct?
Correct, Your Honor.
Then explain to me why you would not show the same courtesy.
Your Honor, we have shown the same courtesy. They also asked for 2 specific adjournments. And in this scenario, the client wasn't willing to give another stipulation to adjourn. We recently received body cam footage of recent calls out to the unit, and
Did that get filed with your response?
no, Your Honor, we actually received it via FOIA request yesterday. And so I was able to watch the body cam footage of what the noises sound like, which really puts into perspective the disturbance that this has caused the neighboring co-owners, which helped me understand why the client was not willing to allow me to stipulate to adjourn.
When did the supposed noises and everything occur?
The body cam footage that I received yesterday, I can give you the specific dates if you could give me one moment, Your Honor.
Yes, please.
So one of the body cam videos is dated 3/10/2026.
3/10?
Yes, March 10th. The other 2 of them are dated 4/13, and then there's one on 4/15, excuse me.
Daniel, you know anything about those?
I don't. I am happy to look into them, but I have not seen any of the body cam footage.
I just
Or-
received them yesterday, Your Honor.
Back to your motion. Did you even, I mean, I'm going to ignore your section 3 regarding the court rules and general discretion not overriding Summary Proceedings Act, because I quite frankly don't think you know what you're talking about, because you haven't gone and looked at 2017, which changed everything. You also have not gone into looking at the way in which summary proceedings are now handled, and that they were specifically overridden by the Supreme Court regarding certain procedural issues, and then incorporated within the court rules that you say don't override particular statutes. And that's just wrong. I can't, it's just blatantly. And obviously, doesn't make any sense to me. If there are issues, certainly, that regarding the defendant's conduct that you become aware of between the time of a trial date and the time of the setting of that trial date, much like every time, and obviously you don't know how this court works, if you filed a request for an emergency hearing on it, this court would do everything to accommodate that. So if there are issues that are involved between the time of the trial date and that, court will address it. But in that regard, we don't practice law here in Washtenaw County by sandbagging. So if you've got evidence of something that is going on, you present that to opposing counsel, see if the resolution can be worked out. If it can't be worked out, you contact my office, you file a motion, much like what happened here. This court will accommodate it within its schedule and get you in to address whatever the issue is. We don't practice this way here, certainly not in this court. I am going to, for the time being, ignore this very poorly researched response. Quite frankly, I think what's in there and it's sanctionable. And I'm going to decline at this time to do that. I will take my request, because it's not going to be defense counsel's request. The request for sanction, I'm going to take that under advisement. So you need to understand, counsel, that doesn't mean that I will not, but I'm not going to at this point. I will also not award to defense counsel attorney fees and costs in this case, but I am going to adjourn the trial date. And I'm going to make it very clear, counsel, so that if you want a written order to that effect, then I'll give you a written order. I don't think it requires a written order. That if there is a circumstance where I find that opposing counsel is not responding, then I am going to sanction, and I'm going to sanction hard. That is not how one practices law. Having considered the motion and the response for whatever the response is, non-jury trial in this matter will be adjourned. I will adjourn the matter to June 2nd, 2026, 9 a.m.
Thank you.
That is all. Mr. Gunn, you prepare an order to that effect, please. Thank
Yes,
you.
sir. Thank you, Your Honor.
Thank you, Your Honor.
This courtroom moment turns tense when the judge realizes something isn't adding up. A defendant tries to argue their position, bringing up documents, filings, and what they believe are legal points. But the judge stops it immediately. Because the problem isn't the argument, it's the way it's being done. The judge makes it clear that's not the issue right now. And just like that, the focus shifts. This isn't about opinions or personal beliefs, it's about procedure. Because in court, how you present something matters just as much as what you're saying. Then things escalate. The judge looks at the filings and notices serious problems. Documents that don't follow proper format, even a case caption that's been changed incorrectly. And that's where the warning comes in. Not emotional, just direct. If this continues, the court may strike everything that's been filed. And when the defendant keeps pushing, the judge draws a firm line. I'm not here to give you legal advice. Because in that moment, the courtroom isn't a place to experiment or guess. It's a system with rules, and breaking those rules only hurts your own case. So here's the real question. When someone represents themselves but doesn't understand legal procedures, should courts guide them or let them face the consequences of their own mistakes? Comment below. Like and subscribe for more real courtroom moments.